When people buy a term insurance policy or a life insurance, they still objectively think of a time when they no longer would be in this world, and they're thinking that they want to avoid the financial distress on their family members who are dependent on them. However, this decision or objectivity doesn't come as easily when one is thinking of writing their own will. Given the unprecedented times we're in right now, and unfortunately, all of us know someone who's passed away, I think the importance of people writing their will could not have been more amplified. For this, in this video, we attempt to give a few tips on what are the best practices in writing your own will. Now, to begin with, you should start with opening an Excel spreadsheet and listing out all the assets that you have, both immovable as well as movable. Mention all bank accounts with complete account numbers, which would be 14, 15 digit. Mention IFSC codes. Mention the branch number of the bank account and the complete branch address. For immovable property, go down to the detail of mentioning the PIN code, the area of the property, any description of the property that you would want to write about. Similarly, demat account numbers to be completely given. For jewelry, it's important to describe the jewelry. If you can, write about the weight of that particular jewelry item, if it has any stones, the color description of those stones, those diamonds, the gems on it. The idea is that as much detail as you go in specifying and identifying a particular asset, the lesser are the chances of there being any dispute around its identification later. And the idea of creating the will is that we want to avoid all disputes. Again, even with yourself, when you refer to yourself in the will, it's important that you mention your government ID proof and your full name with no abbreviations, no initials, but your full name as in government ID proofs. And best to mention ID proof numbers such as your PAN number, your driving license number, your Aadhaar number, so that there's absolutely no ambiguity around your identification. Because if someone challenges your identification in the will, the entire will is null and void. Similarly, when you're mentioning beneficiaries in your will, it's important to give at least two government ID proof numbers of the beneficiaries as well. Along with that, specifically mentioning how those beneficiaries are related to you. That's a very important topic. Now, coming to, do you necessarily need a stamp paper to execute a will? No, you can do it on a plain paper. And you need to register a will? Not necessarily. You can go to the SDM office or the sub registrar to register it to give it more evidentiary value. However, even if it's an unregistered will on a plain paper, as long as it mentions the date, gives the signature date on which you've signed it, which should ideally be the same date on which you're creating it, at the same time mentions that this is your last will and all previous wills, if ever created, to be considered null and void. I think that's enough evidentiary value if you also take other precautions in this process. Now, who are the people involved in your will? One, of course, it's you. So, mentioning your ID proofs in detail and their numbers is very important. The second person is the executor. Now, this needs to be the person who will ensure that the distribution of your assets is done in the best possible manner as you have intended for it to be done and written it in the will. It's best if the executor is a neutral party unrelated to any of the beneficiaries, or if related to the beneficiaries, then possibly in equal capacity. Again, as a best practice, people try to ensure that if there's a trusted family lawyer or a chartered accountant, that person is made the executor. Coming to beneficiaries, you not just have to mention their ID numbers, but also the relation. It's best you mention minimum two ID numbers to identify all beneficiaries. Now, coming to one part that most people tend to miss out on, which is witnesses. You need to have minimum two witnesses in your will. It's best if you can get a lawyer and a doctor to be a witness. There is a reason behind both. A lawyer can ensure that there's legal validity of what you're writing, um, and the doctor is necessary because towards the end of the will, there is mostly a self declaration that says, I'm physically and mentally fit to be writing this, and I'm under no undue pressure or coercion to be creating this will. A doctor can certify the fact that you were physically and mentally fit. If that's not possible, what you can also do is at the same time get a medical fitness certificate of physical and mental fitness from the chief medical officer of a government office and attach that as an annexure to your will to substantiate the same claim. Now, coming to other precautions that you can take while creating that will. You can, of course, type the entire thing on your computer and print it out. However, it would be better if your will is handwritten. A reason being that with a handwritten will, no one can challenge that someone has changed a particular page. So if it's an entire handwritten will of say about 10 pages, it's in your handwriting, and a handwriting expert can validate the fact that it's the same person who's written it at the same time. Again, it's important to put page numbers and not just 1 2 3, but if it's a 10 page will, you should add page 1 of 10, page 2 of 10, page 3 of 10 at the bottom of each page, and so on. That again removes any ambiguity about the total number of pages in your will. And if there is any overwriting or cutting in any part, please rewrite the entire page and replace it and sign it with the proper page number so that there is no dispute going forward. Now, um, coming to the whole idea about how should you store this will, where should you keep it, you can keep it in a bank locker. In fact, you can also seal it in an envelope with certain conditions written on the envelope stating that this will is to be opened only in the presence of XYZ being the executor on such and such condition being fulfilled after I have passed away. You can actually do that and put that in your locker. If you have a lot of holding in the form of shares, in your assets, you could say that 40% of my demat account holding belongs to XYZ person and 60% belongs to ABC person. However, when there are a lot of shares, it makes better sense for you to identify each share and put it to a beneficiary. Also, while writing the will, a lot of people tend to just list out the assets and then give a jumbled form of all beneficiaries who should be getting those assets. A better way of writing it is identify different sections for each beneficiary. So for beneficiary A, it's best to mention all the assets that beneficiary A would have access to in one section. Similarly, a separate section for beneficiary B. These are certain precautions that you can take. One, of course, very important part which people tend to make errors in is if you think that the immovable property is worth 5 crores, saying that 50% of it belongs to this and 30% belongs to the other person, 20% to the third person. People tend to mention values, saying that, okay, from this asset, 2 crores will go to XYZ and 1 crore will go to ABC. But what might happen is value of certain absolute value of certain assets may change with time. So it's best to always define it in percentage terms than giving absolute values. Also, the will has to be signed on all pages, not just by yourself, but also by all the witnesses. The ID proofs and the identification details of the witnesses also need to be mentioned. Again, would hope no one needs such a thing and no disputes arise after people pass away. But again, these are just certain precautions that everyone can take. Share it with someone who may need it.